call the House Labor and Commerce Committee to order at 9:05 a.m. on Friday, April 15th, 2022. Members present are Representatives Kaufman, Nelson, Co-Chair Fields, and myself, and we've got Representative Schrage on the phone. So we do have a quorum to conduct business. Thanks so much to our Secretary, Leah Fraser, and our LAO moderator, Lydia Klein, for joining us today. Lydia's got beautiful earrings again today. A reminder to please announce yourself before speaking for those that are online listening. If you haven't already, this is a great time to silence your cell phones. We have 4 items on our agenda today. We have consideration of 7 of the governor's appointees to boards, an introductory hearing for House Bill 405, establishing trusts, 406, which is a moratorium on trust and property acquisition, and HB 407, prohibiting commerce with Russia. These are all in response to the conflict between Russia and Ukraine. We had originally intended to take final action on SB 174. There was an oversight and public testimony wasn't noticed, and so we will have public testimony on SB 174 on Monday and then take final action on that bill then. So first up, we're going to go to appointees, and we're going to start, I believe, with Val Kudrin, an appointee to the Board of Certified Real Estate Appraisers. Mr. Kudrin, introduce yourself for the record and describe your qualifications for and interested in serving on the board.
Good morning. My name is Valery Kudrin. I go by Val. I'm a residential appraiser. I do appraisals in the Valley, and I've been since 2010. I've served on the board of certified real estate appraisers for a little more than a year. In that time, we've covered a few things like relooking at continuing education requirements as far as being able to complete them all online, and also have been trying to get the qualifying education portion more modernized as well, moving away from only in person to allow for the other education opportunities out there that would still be in line with our goals to strengthen public trust in appraising. That is my primary goal to serve on the board, is to strengthen public trust in appraising by ensuring competent appraisers are certified in the state, and to ensure common sense regulations are in place to assist with that. My experience as a residential appraiser gives me an opportunity to hear perspectives of local Alaskans on the appraisal process as I interact with them regularly when I'm completing reports. If there's any questions, I'd be happy to answer them.
Are there any questions for Mr. Kudrin? All right, there are no questions for you. Thanks so much today for your time and your interest in serving the people of Alaska in your profession. All right, next up, we're going to go to Devin Duran, who I understand just got married. Congratulations. I think her application was potentially under Thomas, but she's changed her name since that point in time. Can you introduce yourself for the record and describe your qualifications for an interest in serving on the Real Estate Commission?
Yes, can you hear me okay?
Can hear you loud and clear, thank you.
Okay, thank you. Hi guys, my name is Devin Duran, and I am a broker and owner of a real estate office in the Mat-Su Valley. I was licensed in 2003. And I like to tell people that real estate's really the only job I've ever had because it's somewhat true. I was mentored in the business by a gentleman named Kyrie Lucas, and at the time he hired me. He was serving as the president of our local board of realtors. So he was very passionate about giving back to our industry, and he gave me a list of committees that our local board of realtors had, and he said, pick a committee and serve on it. And ever since that point in my career, I've made serving and giving back to our real estate community a priority. So I've held many roles in the real estate industry. I've served as a local president. I'm currently an RPAC trustee, and I was the state president in 2017. Which was quite possibly one of the most difficult years of my life, but I made it through, and I'm still extremely glad that I was able to serve our industry in that way. I obtained my broker's license in 2007. I never had the intention of being a broker or owning an office. I just was sick of people asking me how long I had been doing that or how old I was. I've been doing this a long time, and I've always been interested in what the Real Estate Commission does, because I think they are really, they're the ones that can affect the most change with regard to the protection of the consumer and making sure that our business has changed so much since I've started. And I've really seen what they were able to do and able to do in the future to change the way we conduct business because of technology and all the other things, the way the world is changing. And I thought that was a way that I could give back in a different capacity. But the way I think I could serve the Real Estate Commission the most is currently I would be the only commission member that is an experienced educator. I'm a licensed and certified real estate instructor, so I teach continuing education classes. And one of the roles of the Real Estate Commission is to determine what kind of education that we take for our renewal cycle. And that's a way that I've already been able to give back, is to give some input on the guidelines for the continuing education requirements. And this career is just really important to me. It's important that we maintain the integrity of our career, and I'm just excited to be able to serve in this capacity if approved.
All right. Thank you very much. Are there any questions for Ms. Durand? All right. There are no questions for you. Thanks so much for your time and testimony and interest in serving the people of Alaska in your profession. All right. Next up, we're going to hear from Chad Stegan, appointee to the Real Estate Commission. Go ahead and introduce yourself for the record. Describe your qualifications for and interest in serving on the board.
Yes, thank you. Can you guys hear me okay?
Loud and clear. Thanks.
Good morning. My name is Chad Stegan. I'm a broker here in Palmer. I was licensed about 8 years ago. I've been in the industry in different capacities before that, kind of in the construction end of it. I got my broker's license 4 years ago now, and have been brokering my own office here in Palmer since. Part of my reason for wanting to be on the Real Estate Commission and how I think I can help is I have in my 8 years, I've had a pretty well-rounded experience with new subdivisions, land development, property management, and a lot of new construction sales. It's kind of been my wheelhouse for the last bit, and I felt like that could be represented on the board because it's a lot of different or unique kind of aspects of the real estate industry that I've been involved in that kind of help round out the qualifications of everybody on the board, and I can have some value and input in that. Another reason that I have interest in the commission is I think that we need to get in front of protecting consumer privacy with regards to smart homes and smart home products that are being resold in homes. In real estate seminars and things that I've been a part of, it's becoming more and more of a, not necessarily an issue, but a point of concern of how to properly hand off a home when smart devices convey with the house. And part of what I want to do on the commission is help either establish best practices for that so that we can educate not only our licensees but consumers on how to handle that properly, or if there's other actions that we can take, as far as disclosures or things that can better protect not only the licensees but the consumers. And that's what I want to serve on.
All right. Thanks so much. Are there any questions for Mr. Stegan? All right. There are no questions for you. Thanks so much for your time today and your interest in serving the people of Alaska in your profession. All right. Next up, we're going to hear from Dr. Kathleen Rice, an appointee to the Board of Examiners in Optometry. If you can go ahead and introduce yourself for the record and proceed your interest and qualifications for serving on that board.
Hi, my name is Kathleen Rice. I am an optometrist in Kenai. I have been here for 7.5 years. Before that, I was in Fairbanks. And I feel that it is important to give back to the optometry profession in more ways than just clinical care. With almost 17 years of experience, I've worked in the hospital setting, I've worked in a retail setting, at a referral center, and now at a private practice that is actually one of the oldest private practices, oldest optometry private practices in the state. I bought it with my husband in 2015. And having worked in many different settings, I feel like I can relate to optometrists in different areas. Being on the board definitely is important to make sure that the public is safe, and it's important to make sure that the profession continues to be regulated and hold a standard of care so that everyone in Alaska, regardless of their location, can receive similar care regardless of where they live. So I thank you for your consideration.
All right, thanks very much. Dr. Rice, are there any questions for Dr. Rice? All right, there are no questions for you. Thanks so much for your time and testimony today and your interest in serving the people of Alaska in your profession. All right, next up we're going to go to Hannah St. George, who is an appointee to the Board of Certified Direct Entry Midwives. Go ahead and introduce yourself for the record and describe your qualifications and interest in serving on this board.
Yes, hello. My name is Hannah St. George, and I'm from Fairbanks, Alaska. I'm the mother of 10 children and 2 foster children and have attended over 30 births as a support figure. I'm currently working on my doula certification with a focus on postpartum support. I have served as a public member on the board of Direct Entry Midwives for almost 4 years now, and I've really gained a deeper appreciation of what being a midwife entails. Midwifery is a valuable service that people all across the state depend on. The board is dedicated to keeping it accessible and safe for mothers and babies, and they really have a lot of passion and dedication to that. I really appreciate your time today. Thank you for your consideration, and I look forward to continuing to serve on the board.
All right, are there any questions for Ms. St. George? All right, seeing none. Thanks so much for your time today and your interest in serving your profession and or our community and the people of Alaska. All right, next up we're going to go to Gabrielle King, appointee to the Board of Social Work Examiners. Go ahead and introduce yourself for the record. Describe your qualifications and interest in serving on this board.
Thank you, Madam Chair. For the record, good morning. My name is Gabrielle King, and I currently reside in North Pole. I am interested in serving on the Board of Social Work Examiners as a public member. I came to Alaska in 2016 as an infantryman stationed on Fort Wainwright. Honorably discharged in early 2018, I now operate my photography business full-time, traveling to all corners of the state. I am also currently pursuing a bachelor's degree in political science at the University of Alaska Fairbanks. I am interested in serving on the Board of Social Work Examiners as I believe it is a way to give back to my community. Mental health and social services are an integral component for all of us, especially in Alaska. It is imperative that everyone has safe and efficacious access to quality providers in their respective programs. In serving with the board, I believe I can bring fresh perspective to any matters to which the board faces. I'm happy to answer any questions and will return to any that I am unsure of at a later time. Thank you for the opportunity to introduce myself this morning. This is also my first appointment to this board. Thank you.
All right. Are there any questions for Mr. King? All right, there are no questions for you. Thanks so much for your testimony today and your interest in serving the people of Alaska. All right, and our last appointee that we're going to hear from today is Ciara Valero, an appointee to the Board of Veterinary Examiners. If you can go ahead and introduce yourself for the record and describe your qualifications for and interest in serving this position.
Good morning, Madam Chair and members of the committee. My name is Ciara Valero. I'm a new appointee to the Board of Veterinary Examiners. My husband and I moved from California to Alaska in 2012. I graduated from Western University of Health Sciences in Pomona, California, and I've been practicing veterinary medicine since 2007. I'm currently an associate veterinarian and medical director at Tier 1 Veterinary Medical Center. This will be my first time serving on a board. Our profession is rapidly growing and changing, and my interest in serving on the board is to support this growth and the change that comes with it, and to also ensure that veterinarians continue to provide high-quality medicine. If there's any questions, I'm happy to answer them. Thank you for the consideration.
All right, are there any questions for Dr. Valero? All right, there's no questions for you. Thanks so much for your interest in serving the people of Alaska and your profession on this board, Dr. Valero. All right, and I'm going to go ahead now and open up public testimony on the appointees that we have heard from today. Is there anybody in the room who'd like to testify? Is there anybody online? All right, there is nobody online. We're going to go ahead and close public testimony. All right, so next up, we're going to go to a first hearing of 4005, Establishment of Trusts by Representative Fields and Evan Anderson, and this is part of a package of legislation that this committee is considering regarding Russia investment in Alaska.
Thanks, Madam Co-Chair. Zach Fields, House District 20. And just for the committee's background, we did put in legislative requests for this legislation shortly after Russia invaded Ukraine. And, you know, as soon as that invasion happened, I think people started asking themselves, what's my role as a citizen, maybe at the level of state government, in supporting the free people of Ukraine and making sure that we're not inadvertently giving Putin and his allies access to resources that they would use to wage war on Ukraine. And I know that Representative Nelson had a really positive resolution supporting aid to Ukraine. Many of us participated in urging divestment of permanent fund assets. And I think the bills before you today are ones that required a little more research. But basically the idea here is to make sure that oligarchs aligned with Putin or his family members are not able to shelter wealth, generate wealth in Alaska. So there are two bills on trusts and property, and then there's one bill on preventing offloading of Russian imports at Alaska ports. And because the trust bills are fairly technical, I'm going to turn to my coworker Evan Anderson to go through the background on what is our trust law and how do we make sure that oligarchs are not sheltering their wealth here.
Thanks. For the record, Evan Anderson, staff to Representative Zach Fields. I'll be presenting on House Bill 405 and 406. To start, we'll talk about House Bill 405, which deals with the establishment of trusts. House Bill 405 updates Alaska law to ensure trusts here in our state will not be used to shield assets of Russian oligarchs or other enemies of the United States. It ensures state law is consistent with federal transparency requirements, and it provides clarity for industry as well as state and federal regulators moving forward. I think it might be important for us to take a step back and make sure we're all on the same page when we talk about trusts. The graphic on this slide might look a little complicated, but it's a visual depiction of the complex web of relationships formalized by a legal trust. A basic trust is a three-way arrangement. A settler on the left there is, for example, maybe a rich grandfather. The settler puts assets into a trust, which is managed by a trustee, typically a lawyer, on behalf of beneficiaries, for example, the grandchildren. On the chart, you see a couple of other terms there as well, and we won't get into them for now. There are many different types of trusts. For example, a discretionary trust is where the trustee has discretion to decide who gets what, when. The beneficiaries can argue that until they receive a distribution, they aren't entitled to any of the trust assets because it's all up to the trustee. The assets have been given away by the settler, but nobody is entitled to them yet. So they are in what's considered an ownerless limbo, ring-fenced from tax, from creditors, or from the rule of law. I want to be clear, the vast majority of people with trusts in Alaska are law-abiding U.S. citizens who deserve to plan their estates and set assets into trusts for their family members. That flows into the history of trusts in Alaska. History of trust goes back quite a ways. Prior to the Alaska State Constitution, we can trace trust law back to England in the Middle Ages, and it spreads throughout most countries that operate off of common law. From 1959 to 1998, so from statehood to just 25 years ago, trusts in Alaska operated as they do in the vast majority of states and common law countries. In 1998, Alaska became the second state in the country to enact super trust laws, and we'll get into this a little bit more in another slide. Now, for the past 24 years, Alaska initially captured quite a bit of national investment. However, as other states joined South Dakota and Alaska, including Nevada, Delaware, and Wyoming, each enacting new laws to expand the authority of trusts in their state, that increased competition led to many of the largest accounts leaving the state. In October 2021, a series of leaks revealed that Alaska and these 5 other U.S. states have attracted vast sums of wealth and could be sheltering funds for the globe's most violent and corrupt criminals. Now, how can we compare Alaska's trust laws to others around the country and the globe? This index by the Tax Justice Network, called the Financial Secrecy Index, is a globally recognized measure of how secrecy laws impact global financial flows. You'll see orange blobs in the locations where there's the most, the best measure of secrecy and thereby the most global financial flow. This index from 2020 puts the United States at number 2 on its list, right behind the Cayman Islands. South Dakota, Alaska, Nevada, and these other U.S. states are the main contributors to the U.S.'s place on this list. And just how do Alaska's trust laws compare with those in other states? This is you can find this in your supporting documents as well. It might be a little bit small on your screen, but this is actually marketing from Bridgeford Trust Company, South Dakota-based trust company. They're a private firm that publishes this information on their website as a comparison. Bridgeford Trust Company specializes in marketing South Dakota and other U.S. states to some of the wealthiest families in Latin America. Alaska is number 4 on its list. In our presentation today, you'll hear multiple references to the Pandora Papers. Released in October 21, the Pandora Papers reveal a small slice of the extent to which American companies are involved in global tax evasion, money laundering, and corruption. We won't have time to go through all of the examples from the Pandora Papers today, but there's a few that we've drawn out for you today. The story of Federico Kong Vielman is one that we thought worth sharing. A Guatemalan business person, the leaks show him with $13.5 million in assets held in trust in South Dakota. His palm oil company has been cited by the U.S. government for hiring workers for inadequate pay with inadequate safety protection. His company has also been named as a contributor to toxic pollutants in a local river. Although Guatemalan courts took action on the other companies named in that citation as causing the pollution, they did not take action against the Kong Vielman family. Despite the very real possibility that U.S. trusts are being used to shelter funds for oligarchs and dictators, there is some good news. The global community has taken major steps, especially in the last 10 years, to enact reforms. The Financial Action Task Force issued its recommendations in 2012. Initially, this was an intergovernmental initiative of the G7 countries which dates back to 1989. This intergovernmental organization has grown to now include 39 global members, including the United States, and its recommendations set up a framework that that give us here in Alaska something to follow. We can also look to the European Union, which has issued 5 anti-money laundering directives over the past few decades, most recently requiring public disclosure of beneficial ownership information for trusts. In 2018, even the Bahamas enacted reforms. And since 2018, we've actually seen, and it shows up in the Pandora Papers multiple times, much of the accounts that left the Bahamas when they enacted reforms have moved into U.S. states, many of them to South Dakota. So as of 2020, 17 of the least restrictive jurisdictions for trusts anywhere in the world are U.S. states. And that's where federal regulations start to come in. In 2021, the Corporate Transparency Act was signed by President Biden into law. And I share it here because it comes up in one of our later examples. The UK, which has been one of the other most permissive places in the world for trusts until recently, just last month passed the Economic Crime Transparency and Enforcement Act following the Russian invasion of Ukraine. So which U.S. states have the most trusts in the Pandora Papers? By far, it's South Dakota. We actually don't see Alaska named on this list of the top 5. But to be clear, this is not a complete picture of the problem. It's just one leak. We don't have any way of knowing the full extent to which Alaska is involved. And what does all these policies have to do with Russia and its oligarchs? We know that Russian President Vladimir Putin built his war effort with the profits from oil and gas, seafood, and other trade goods. And this is a quote from Ian Gary, Executive Director with the FACT Coalition. The secrecy currently afforded by the U.S. and other Western legal and financial systems contributed to President Putin's empowerment. I'd like to stop here for questions, and then we'll take invited testimony from Ryan with the FACT Coalition.
Madam Co-Chair, this is Zach Fields. Before we go to questions and our invited testimony, I just want to note Alaska's trust laws are currently so opaque that we wouldn't know if oligarchs are sheltering their assets here, hence the need for the legislation.
All right, thank you. And as was noted earlier in the presentation, it is also important to know that trusts are used by many law-abiding citizens, and the intention, I think, is in this legislation is to address those who are using Alaska as a way to avoid the law. I personally, my family has 2 trusts, for example, and I wouldn't consider my family wealthy even. So they're just a very useful tool for family planning often. Representative Kaufman.
Well, thank you to the chair. Are you admitting that you're an oligarch?
I'm definitely not an oligarch, Representative Kaufman, but you can see my legislative financial disclosure to verify that.
Through the chair, so far this presentation seems to be impugning trusts, and I know many citizens. I know a couple times there's been disclaimers, but I guess I want to see more clarity around the problem statement that we have here. One person's secrecy is another person's privacy, and a lot of those people are citizens that deserve privacy. So I hope we have clarity on this going forward.
Yeah, through the chair, I agree that most people who use trusts are law-abiding citizens who are using trusts for perfectly legitimate reasons. And I think it's actually the trickiest public policy situation where you have the vast majority of people who are law-abiding and want to do the right thing, but a small percentage of lawbreakers who would attempt to exploit a system. So how do we make sure that the small percentage don't exploit a system that many law-abiding people participate in? And that's the goal. And I think when you look at House Bill 405 and 406, they're largely transparency requirements that would do no harm to everyone who's a law-abiding family trust holder.
Mm-hmm. And it might be helpful if before we go to the invited testimony, if you just walk us through the specific sectional in the bill so we can be really clear on what the bill does and does not do as we move forward and continue to understand the problem statement and what the remedies being proposed does.
For the record, this is Evan Anderson, staff to Zach Fields. Happy to walk through the sectional for House Bill 405. We have actually gotten a committee substitute draft back, so we will potentially have some changes to walk through if next time this bill comes up for a hearing. But for now, the original version of the bill, version A, I'm glad to walk through. So for section 1, and I also have maybe a slight addendum to the answer for Representative Kaufman's question I'll name after this. For section 1, that amends existing documentation requirements to require an address, either business or residential address, as part of the initial court filing. We, in lengthy discussions with legislative legal, realized that our existing structures in statute do not, if a trust does not have a business address associated with it, then no address is required for filing. Many trusts, as we've discussed, are family trusts and might have nothing to do with a business, and so this seemed like a clear loophole that was easy for us to close. Section 2 amends AS 13.36 by adding a new section to require trusts to file establishment paperwork with the Department of Commerce, Community, and Economic Development, including the names of the trustee, the settlor, the beneficiary, and the person or individual filing the documentation. DCCED will establish a fee for establishment. This section affirms the confidential nature of trust information. Public disclosure of private information contained within trusts is unlawful and would remain unlawful after enactment of this bill. DCCED has non-disclosure agreements in place for staff and other departments to retain confidentiality of this information, and non-disclosure provisions could be expanded to Division of Banking and Securities staff handling confidential trust information. This section allows DCCED also to release information to the U.S. Department of Treasury. This is a logical next step for protecting Alaska's trust industry, and makes it clear that the funds for war criminals and terrorists are not welcome. The third section provides for an effective date. Something that came up a number of times as we were discussing this was if this could apply to trusts created in the past, and no. The answer from Legislative Legal was that we can only apply these new regulations to new trusts or trusts that maybe are making amendments to their structure in the future.
All right, thank you. All right, and with that, did you want to address the question and then we'll move on to invited testimony?
One quick thing I'll say is that you saw on the slide about global reforms where some jurisdictions around the globe are requiring public disclosure of beneficial ownership information. That is not what we're intending to do in this bill. That would be going further than the Corporate Transparency Act at federal law, which also does not require public disclosure of that information. It creates a central registry through the U.S. Department of Treasury. And so I just want to be really clear about that. There's no risk to the confidentiality of that information.
All right, thank you. Do you have a follow-up to that, Representative Kaufman, before we go to invited testimony?
No.
All right. All right, thanks so much. All right, we are going to go to invited testimony from Ryan Gurule. Hopefully I'm pronouncing your name correctly, with the FACT Coalition. Can you go ahead and introduce yourself for the record and proceed with your testimony?
Yes, and that pronunciation is correct.
Oh,
thank you.
It's a miracle. Thank you so much.
It's a tough one. Good morning, and thank you for having me. For the record, my name is Ryan Gurule, and my affiliation is joining as the Policy Director of the Financial Accountability and Corporate Transparency, or FACT Coalition, a broad, nonpartisan alliance of members dedicated to standing up structural reforms to combat harms flowing from financial secrecy and vulnerabilities in the U.S. financial system that facilitate money laundering, sanctions evasion, corruption, tax dodging, and illicit financial flows. We were greatly encouraged by our invitation from Rep. Fields to speak with you this morning, and impressed by Evan's testimony as well, on the important topic of trust secrecy in Alaska and the Pandora Papers. The Pandora Papers offer concrete evidence of a simple fact. The U.S. is a singular financial secrecy jurisdiction. This undesirable status erodes our and our allies' tax base. It undermines our national security and compromises our financial markets, and it weakens democracy here and abroad. The effect of these harms manifest not as academic concerns, but by directly impacting our local communities. Further, we must acknowledge that the financial secrecy afforded by the U.S. and our allies have previously enriched and empowered potentially adversarial regimes, including those of Russian President Putin, giving his inner circle a backdoor to evade the bite of earlier sanctions and emboldening the corrupt and criminal behavior. The risks that financial secrecy pose are why President Biden's administration and bipartisan efforts in Congress have prioritized bringing greater transparency to U.S. legal entities in the fight against corruption. Dismantling secretive systems that enable corrupt actors and tax dodgers to avoid accountability can also make well-coordinated sanctions targeting the wealth of Putin and oligarchs more effective today. Equally important, Doing so makes it less likely that similar retaliatory efforts against kleptocrats will not be needed in the future. Anonymous shell companies and arrangements capable of being formed or otherwise investing or doing business in the U.S. pose one of the biggest vulnerabilities to the U.S. financial system. According to an analysis by Global Financial Integrity, a FACT Coalition member, until recently, in all 50 states, including Alaska, more personal information was needed to obtain a library card than to establish a legal entity or trust that can be used to facilitate tax evasion, money laundering, fraud, and corruption. The Pandora Papers specifically implicate U.S. trusts as one of the most significant gaps in U.S. anti-money laundering regulatory regimes. Unfortunately, Alaska has its own sordid history with commoditizing financial secrecy, making the proposed reforms discussed today all the more critical. In the 1990s, struggling with depressed oil prices, Alaska was understandably looking for new ways to attract outside capital investment. From that position, Alaska considered and passed changes to its trust laws, first suggested by a New York lawyer, that would push the state far outside existing trust laws and soon would result in other states like Delaware, Nevada, and South Dakota following Alaska into the rabbit hole. The result is a competition for foreign capital seeking not just protection for future claims against heirs, but effective anonymity. The benefits of this anonymity for out-of-state tax dodgers, corrupt politicians, and others seeking to avoid public accountability has been obvious since the start. Whether equivocal and offsetting benefits have been realized by Alaska's citizenry or that of other states that are victims of this race to the bottom for attracting shadow capital is more questionable. And as international tax and financial transparency measures have begun to peel back secrecy in traditional tax havens, cross-border deposits in U.S. financial institutions, often held in trust or via other legal anonymous vehicles, has substantially increased. Already we know from the Pandora Papers that U.S. trusts are being heavily abused. The same secrecy afforded by Alaska created the impetus for a known human rights violator to relocate his trust assets from the Bahamas to the U.S., for example. We should be clear, however, that the Pandora Papers are just one leak of data and should not be viewed as indicative of the entire universe of problematic anonymous U.S. investment by corrupt or criminal actors. Rather, the Pandora Papers serve as an indictment of the financial secrecy afforded by U.S. laws, including those in Alaska. Last year, Congress finally took steps to address the threats posed by anonymous legal entities and passed the Bipartisan Corporate Transparency Act on January 1st, 2021, a measure that requires corporations, limited liability companies, and other similar entities formed or registering to do business in a state by filing with Secretary of State or a similar office to disclose their true natural owner to a secure directory housed and maintained at Treasury's Financial Crimes Enforcement Network, or FinCEN. The FACT Coalition previously filed comments on best practices for establishing this directory in response to FinCEN's first proposed rulemaking, including addressing who should file disclosures, when they should file, what information they should provide, and how certain exemptions should be handled. FinCEN has announced that it plans to issue a second proposed rulemaking, addressing access to the directory, including by state, tribal, and local law enforcement agencies. And FACT has advocated for uncomplicated and complete access for authorized users. Yet, the application of the CTA to certain trusts remains unclear. For those trusts that file only with local courts, or that do not file at all in connection with formation or other key events, such as relocating to Alaska, the CTA may apply to varying degrees based on final rules when promulgated. House Bill 405 takes important steps to clarify the application of the Corporate Transparency Act to trusts administered in Alaska, and to also make clear that Alaska will have ready access to the information necessary to ensure that its trust industry is attracting the type of investment that does not put Alaskan citizens at risk of greater national security threats or rising prices contributed to by global geopolitical conflicts. FACT supports HB 405 and Alaska's innovative efforts to pivot from the secrecy rat race toward being a singular leader in promoting greater financial transparency. To ensure that HR 405 brings greater transparency to the trust industry in Alaska in a way that does not afford workarounds to bad actors and helps to bring about an end to the American tax haven, FACT urges Alaska to ensure that this bill advances, incorporating the following policy recommendations. At a minimum, beneficial ownership reporting should apply to any trust governed by Alaskan law administered in whole or in part in Alaska or by an Alaskan trustee, or that otherwise has situs in Alaska. Legacy trusts should be timely incorporated in the regime, as should any relocating trusts. All relevant actors should be covered. A strong definition of beneficial owners should look to control of trust governance and assets and rights to or control over distribution of trust assets, including for protectors, trustees, settlers, or grantors, and certain beneficiaries. The bill should create a clear affirmative obligation for Alaskan trusts to file under the Corporate Transparency Act. The bill should require ongoing reporting, monitoring, and verification. Changes in beneficial ownership should be reported in a timely fashion, and data best practices should apply to the collection, storage, and authorized dissemination of information collected under the bill. While we would expect reporting burdens to be minimal in all but the most complicated structures, which are likely purposefully opaque, employing standardized best data practices only further reduce reporting costs. Additional secrecy rights should not be created by the bill, and appropriate penalties or distribution prohibitions for any party that provides false information directly or indirectly, or that fails to provide required information should be considered. These reforms will also help to ensure that House Bill 406, which we'll discuss next, I understand, is effectively implemented in Alaska, again ensuring that sanctions against oligarchs cannot be avoided through secrecy. In conclusion, our system of federalism is made better when states innovate in ways that reinforce our democracy, our open and transparent markets, and our national security. The opposite is true when states compete for investment through financial secrecy to lure potentially corrupt, illicit, or criminal capital. This legislative body, just like Congress, has an important role to play in ensuring that the Alaskan and U.S. financial system are not vehicles for tax dodging, corruption, human rights abuses, or other financial harms. I want to thank you again for inviting FACT to participate in this important process, and I look forward to our conversation.
All right. Thanks very much for your testimony, Mr. Rule. And it does sound like I did butcher your name, and I apologize for that. With a name like my last name, like Sponholz, I try to be sensitive to that, but yours was a new one for me today. Are there any questions for Mr. Rule? All right. There are no questions for Mr. Rule, and I believe that we've got also Robert Schmidt with the Division of Banking, Division of Securities on. Is he going to provide testimony today?
Through the co-chair, maybe I could just ask Mr. Schmidt to address what potential problems there could be with such opacity of trusts and the risk for abuse. If he could speak to that based on his experience, I would appreciate it.
Mr. Schmidt, you heard the question, and also I'd like you to address in the fiscal note, you said you already have a system that could be used for handling the transparency elements that are incorporated here, and if you could just describe that for the committee as well, that'd be helpful. Thank you.
Thank you, Representative Sponholz. My name is Robert Schmidt. I'm the Director of the Division of Banking and Securities. I'd like to provide just a little bit of clarity in my division's role with trust as it is now. The Division of Banking and Securities regulates trust companies, but we do not regulate trusts. We perform safety and soundness examinations of trust companies under Title VI, those are the banking statutes, Title VI of the Alaska statutes. If a trust has assets on deposit in a state-chartered financial institution, we also perform safety and soundness examinations of those financial institutions under Title VI. But we do not examine, register, license, approve, or otherwise review individual trusts which are governed by Title 13. Banking and Securities appreciates the concern that Alaska trust laws may be used inappropriately, and I will be speaking with this committee actually next week on House Bill 408, which addresses that identical concern. But the committee will also have to balance and consider how trusts are being used as an estate planning tool by everyday Alaskans. So with that being said, I have with me my Chief of Examinations, Tracy Reno, and then also I have two examiners with me, Ryan Dukowitz and David Braun. And I would ask that Tracy Reno address the question regarding the fiscal note.
Ms. Reno?
Reno, I'm the Chief of Examinations. Thank you. For the record, my name is Tracy Reno, and I'm the Chief of Examinations for the Division of Banking and Securities. And I can speak a little bit to the database that we currently have that may be useful in this bill, we use STAR, and it basically is a repository for information, so we can save electronic documents in there and have contact information reserved in there. The bill, when we considered it, there may be some other things that we need to consider and research. OFAC, the Office of Foreign Asset and Control requirements, it's not a one and done. You have to do onboarding. You have to have certain things that you have to identify with individuals, dates of birth, middle names, those types of things, possibly identification. And then once those trusts change or amend, there will be updating of that information. If there's a requirement for the division to check this information against OFAC or sanction lists, it would probably require additional vendors that would have to be brought on to be able to check those lists periodically, depending on how often you want to do that, because they change probably daily, if not hourly, depending on who's being sanctioned. So countries and individuals. So there's a lot of digging and research that we'll need to do, but we can have a repository to hold the information. But the next step, as far as if there's something else you want us to do with that, then there's going to be a little bit more research that will need to be done. Probably reaching out to OFAC to actually find out what we would have to do, how it would be reported, with the liabilities for employees if we fail to identify someone on a sanction list. And don't report it. So there's information that we just don't have at this point. I think the bill definitely is dealing with a situation that we should be concerned about. There just needs to be a little bit more work to get into the weeds and into the details.
Okay.
And I'm happy to answer any questions.
Representative Fields.
Thanks. Through the co-chair, I just wanted to ask Ms. Reno and Mr. Schmidt if they could confirm the basic process that would happen if these bills were enacted, and I really appreciate their guidance on making sure they're workable for the department. Mr. Schmidt and Ms. Reno, is it accurate to say that if HB 405 and 406 passed and we required these trusts to disclose who their beneficiaries are to you, again, they're not disclosing them to everyone in the public, and you, and probably working with a vendor, identified that there was, say, an oligarch on a sanctions list, my understanding is you would then report that to the Treasury Department, and it's actually the Treasury Department that would take action to freeze the assets of, say, a foreign aggressor who's attempting to shield their assets here. The state is really just conveying that information to Treasury. We're not, going out and seizing the yacht. Is that an accurate depiction of kind of the chain of identifying information and taking action?
This is Tracy Reno. Go ahead, sorry.
Go ahead, Tracy.
This is Tracy Reno. That's my understanding, but it's unconfirmed. I would need to speak with OFAC to determine what steps would need to be taken and how and when. And again, that responsibility of holding that information, that personal private information, and reporting it to OFAC, or to the Department of Treasury. We don't currently do that, so I don't know all the steps or the things that would have to be in place for that to happen. So I think that sounds right, but I would have to confirm it.
All right, and I would expect that there would be some sort of like risk-based analysis of whether, of sort of cross-referencing, so you weren't on a daily basis having to check databases. We're not talking about like a massive expansion of your daily workload, but that there would be some sort of, internal risk assessment with regards to which trusts were more likely to need to be checked against the federal, against the potential offenders that we want to be, or bad actors that we want to be looking for. And we're not talking about the Kiker-Sponholz Family Cabin Trust, for example.
Yeah, this is Tracy Reno. So the bill says that every trust, and tell me if I'm wrong, every trust that's established will have to file this paperwork with the department, and then my understanding is we would be running this information against the OFAC list in some way, shape, or form. So I think every trust coming in that we're holding information on would have to be run periodically through the database or through the sanctions list with a vendor, because it, like I said, those lists change daily, and it would be an automated system, I would assume, through a vendor that would be doing this periodically.
And this could hypothetically be done like on an annual basis or something.
I think there's requirements for OFAC to, if you identify it or you have to do it so often, to report it within a certain period of time, or you can be held liable for criminal penalties. So I don't know those specifics.
Okay, it sounds like there's some follow-up questions that we'll ask you to get back to the committee on, so we can make sure that we've got all the information and available to the committee. Is there anything additional that you would like to add, Representative Fields, before we move on to the next bill?
Sure, thanks, Madam Co-Chair. I think Zach Fields, for the record, I think the key here is if we as a state don't identify potential oligarchs who might be sheltering wealth here, then the federal law is rendered ineffective. So we actually have a really important state role.
Mm-hmm. Absolutely. And all right, next up, we're going to go to House Bill 406.
For the record, this is Evan Anderson, staff to Rep. Fields. House Bill 406 is a moratorium on trusts and property acquisition in the state. You've already heard the term OFAC thrown around, and we'll get into that a little bit more soon. But House Bill 406 updates Alaska law to ensure trusts held or managed by enemies of the United States can no longer operate in the state of Alaska. It also prohibits these individuals from acquiring real estate. This is the biggest difference between this and House Bill 405. It also protects Alaskans' access to services provided by trusts, such as estate planning, while ensuring foreign adversaries cannot hide their wealth in Alaska. So you've heard the term Office of Foreign Asset Control. That's a division of the U.S. Treasury Department that has been active in one way or another since 1940, when Nazi Germany invaded Norway. The Treasury Department since then has used its economic power to freeze assets of enemies of the United States. Its authorities were expanded in 2016 with the Global Magnitsky Act. And it's important to note, and it gets a little confusing, so it's worth noting, that the sanctions from the Office of Foreign Asset Control target individuals, not entire countries. I think a lot of the time when we hear the word sanction, we think about country to country, but these are for individuals who are deemed enemies of the United States. Financial transactions with individuals on the sanctions list are, of course, prohibited for U.S. citizens, which makes it all the more concerning that our in-state trust laws could potentially conceal some of these transactions. And as we've mentioned, the Pandora Papers have revealed that U.S. states like Alaska have trust laws so strong that they may effectively conceal assets of international criminals. So, to share a couple more stories from the Pandora Papers, this photo shows Monaco's luxury Monte Carlo Star apartment complex. It's located steps away from the world-famous Monte Carlo Casino, and this is an image of it on October 6th. The image is a little cut off, but that's a pretty nice marina full of yachts right in front of the apartment there. It was worth $3.1 million when it was cited in the Pandora Papers. So the International Consortium of Investigative Journalists, ICIJ, recently reported that one of the multi-million-dollar flats inside this building was purchased in 2003 for Svetlana Krivonik, gonna try that again, whom some reports have identified as the rumored mother to a child of Russian President Vladimir Putin. Leaked documents what we know is that this was purchased through a Caribbean-based shell company. So why is it that criminals like trusts? I thought this quote from a World Bank report issued back in October 2011 was especially apt. Trusts prove such a hurdle to investigation, prosecution, civil judgment, and asset recovery that they are seldom prioritized in corruption investigations. Investigators and prosecutors tend not to bring charges against trusts because of the difficulty in proving their role in the crime. Pictured here is Alisher Usmanov, one of Russia's most notorious oligarchs. He's made a lot of headlines because until recently he was the majority owner of Arsenal Football Club in the UK and a major financier of Putin's efforts in Russia. So why has Mr. Husmanov made news? Just a few weeks ago, his spokesperson was quoted as saying that his assets, including a yacht and a London apartment, were out of reach of sanctions in the United Kingdom, although they were located in the United Kingdom. And we can do something about these legal loopholes that are right here in Alaska, and it involves taking the next step to integrate our state's trust into the existing federal enforcement mechanisms. And I'll stop there for any questions.
All right, why don't you walk us through a sectional of the bill before we move on?
Absolutely. Through the chair, Evan Anderson, staff to Rep. Fields. This is the sectional analysis for House Bill 406, version B. Section 1, AS 13.36 is amended by adding a new section that strips a trust of its legal status in the state of Alaska if any individual associated with it is named on the sanctions list by the U.S. Department of Treasury. I won't name the definitions for the relationships in a trust again as I named them earlier, but they're listed there for review. Section 2, AS 40.17.070 is amended by adding a new subsection to make it impossible for individuals on the U.S. Department of Treasury's sanctions list to acquire, sell, or gift real property in the state of Alaska. The mechanism for this is through the Recorder's Office in the Department of Natural Resources. They're responsible for keeping records on real estate transactions. The Recorder's Office can utilize the Office of Foreign Assets Control sanctions list to avoid any future sale or gift of Alaskan properties to individuals on the sanctions list. And finally, Section 3 provides for an effective date. And again, just like House Bill 405, this bill will not impact trusts or real estate transactions that were completed prior to its effective date.
All right, thank you for that. And next up, we're going to go to invited testimony, and we're going to hear again from Mr. Gurule with the Fact Coalition.
Great, thank you. Again, for the record, my name is Ryan Gurule. I'm testifying on behalf of the Fact Coalition. My testimony will be much more brief this time, but the Fact Coalition would only urge Alaska to consider typical real estate anti-money laundering topologies and creative corporate structuring that is available to sanctioned individuals, such as the ability to purchase real estate through trusts or other anonymous legal entities or arrangements or nominees in promulgating House Bill 406. House Bill 406 would need to contemplate and look past legal blinders to identify problematic buyers. In other words, HB 405 will help to ensure that House Bill 406 is effectively implemented in Alaska, as would similar measures with respect to other topologies. Again, ensuring that sanctions against oligarchs cannot be avoided through secrecy, and that Alaska is encouraging the type of investment that will ensure the long-term growth of the Alaskan economy to the benefit of the Alaskan citizenry.
All right. Thank you very much for that testimony. And we again have online available for questions. We've got Robert Schmitz with the Division of Banking and Securities. We've got Christy Thurman with the Department of Natural Resources. We have Abigail O'Connor with O'Connor Law, Matthew Blockmacher with Peak Trust Company, Ryan Gukowitz with the Division of Banking and Securities, and then Terry Bannister with Legislative Legal, all available for questions at this point in time. Are there any questions from members of the committee for any of these potential invited testifiers? Brief eddies. All right, We are back on the record. Are there any questions for Representative Fields or Staff Evan Anderson?
I might, Madam Co-Chair, if I could just
Go
give
ahead.
closing comments on
Yeah.
405 and 406. The way I see it is, if Alaska's a house, we want to make sure, rats and cockroaches aren't in the walls and can't come in here. The international criminals who use trust to shield their assets are like vermin. And we can't control what South Dakota does. We can't control what Nevada does, but we can protect our house. And we could set a good example with state laws in our state and, create more of a race to the top than a race to the bottom. So these bills are very important because I think it's a reality that the way Putin operates, and we can presume the way that other rogue regimes will operate, is through informal networks of hiding and generating wealth, including through criminal organizations. And Alaska has to do its part to stop someone like Vladimir Putin from deriving funding for a criminal and aggressive regime. Thank you.
Thank you. And I want to thank you for introducing these bills. You always are very ambitious in your topics and your content, and are really strong advocates for consumer protection and for Alaskan sovereignty. And I really appreciate that. I also, firmly believe that the committee process will make the bill better, as we always do in House Labor and Commerce. And want to be really clear with everybody that it's not our intention to undermine individual Alaskans or good acting Americans that want to establish trust. The trust industry in the state of Alaska is an important part of our overall commercial spectrum. And as I mentioned, most trusts are actually just family trusts that are designed to make it easy to convey assets. My family, as I mentioned, has two. One is to help care for a child that has a disability in the event that my husband and I aren't able to do that anymore, and another is to transfer a family cabin trust and keep it in the family and keep us all on the same page with that. So there's a lot of real practical reasons why everyday working people have trust. You don't have to be a Russian oligarch to do it, but what we do want to do is to create that transparency in the state of Alaska to ensure that we're not a part of propping up bad actors that might take advantage of our trust system in the state of Alaska. So with that, we're going to move on to the next bill, which is House Bill 407 in the suite of legislation that we're considering from the House Labor and Commerce Committee today. Representative Fields.
Thanks, Madam Co-Chair. This is, for the record, Zach Fields, House Bill 407. Very simple bill. Prohibits the importation of Russian goods, specifically by using our powers of state to prohibit Russian boats from docking at Alaskan ports and offloading goods and materials. I think you may have read in the media, number one, that the late Congressman Don Young introduced an important federal bill on this point. Some of the assets of some of these Russian oligarchs who were enriching Putin have been seized by other nations. Congress has taken swift action to make sure that on the federal side, there's strong federal law prohibiting the fueling of the Russian war machine through Russian imports. I also want to reference, obviously, we have a lot of commerce with Asia and with Europe in Alaska. And I want to recognize that, longshoremen across the country have, on their own, just refused to unload Russian products at ports. I think we as a state should just ask ourselves, what are we doing to support democracy, to support the free people of Ukraine, and to make sure that we're not sending a single dollar to Vladimir Putin and his aggressive regime. This simple bill will make sure that Alaskans don't inadvertently provide him financing. So, again, this is what we can do to support the war effort. I'm happy to answer questions, and we do have invited testimony from the Marine Exchange and Alaska Marine pilots.
All right, let's start with the sectional analysis. Mr. Anderson.
Thanks, through the chair. Evan Anderson, Staff to Representative Zach Fields. This is House Bill 407, version A. Section 1, AS 30.50, is amended by adding a new section to prohibit all Russian ships from docking at ports in Alaska. This includes Russian-flagged vessels, ships that are crewed by Russian nationals, and ships that carry Russian cargo. This is important to mention because, as you'll hear in some of our invited testimony, we are typically only tracking information on flagged vessels, and there are other vessels that come into Alaska waters that are often crude or carry Russian cargo that are not always tracked under some of our measures. Section 2, AS 45.45, is amended by adding a new section that bans all imports and exports with Russia, including seafood, alcohol, and oil and gas. Section 3 amends the uncodified law of the state of Alaska with a new section that permits specific trade with Russia, including the docking of specific vessels if contracts were signed prior to the effective date. This is an important measure so that we don't impair existing contracts. Section 4 repeals sections 1 and 2 of this bill automatically after 10 years. We don't envision that we close trade with Russia forever. That's, I think, not the goal of the drafters or most anyone in this country. But we wanted to set it far enough in the future to allow for the establishment of normal trade relations again. Section 5 amends uncodified law with a new section that automatically repeals the provisions of this bill banning commerce with Russia if the current security risk is resolved and the U.S. government lifted sanctions on Russia. So that 10 years is kind of the furthest out if there isn't a normal trade relation reversion before then. Section 6 allows Section 4 to take effect. Similarly, this just allows Section 5. It's DCCED commissioner who would be responsible for receiving that information from the federal government, and they would have the power to restore trade and restore ships coming to port if Section 5 comes to pass. And then Section 7 provides for an effective date.
Are there any questions on the sectional? All right, seeing none, we're going to go up to invited testimony. We have here in the room Steve White with the Marine Exchange of Alaska. Mr. White, go ahead and introduce yourself for the record and proceed with your testimony.
Thank you. For the record, my name is Steve White. I'm the Executive Director of the Marine Exchange of Alaska. And I think I might have some slides here. Thanks, Evan. So we've done some traffic analysis on Russian ships and ships that are associated with Russia or Russian companies to provide here. It's it's one of the things we do over at the Marine Exchange is traffic analysis, sea traffic management, and some of this was actually done in preparations for some stuff for the federal government on ships that come to Alaska. And this first one slide here is the Sovcom Flot vessels, SCF, I'll call them from here on out. These is a Russian-owned company. It's Russia's largest shipping company. They have a particular focus on moving hydrocarbons, jet fuel that comes to up to Anchorage to support the airport there. And they've made 12 port calls in the last 10 years. They are not Russian flagged. They are flagged by Liberia, which is common practice, flagging in another country. And there was 3 of these in the last year that visited. This slide that we're looking at right now, the black lines are ship's tracks, and they are ones that actually came to Alaska. The white lines are the same company, but either went to, you can see Canada or Washington. Now, this is just a little more analysis on it. This is where they came from. This is why it's kind of hard sometimes tracking these boats and getting your arms around this issue. These are the tracks where they came from east to west to hit Alaska ports, but they originated in Korea. But you can see that before they were in Korea, they came from Russia. And again, it's a Russian-owned company, not necessarily Russian flagged.
Mm-hmm.
And this is when they're going back from west to the east, and they went to Russian ports instead of heading back down to South Korea. We put this on here just shows the massive amount of Russian traffic close to Alaska borders. This is up in the Bering Strait, and the slide on the left is all the tracks, and they're broken down by what portion of the maritime industry they are. And you can see there's a lot of blue there. It looks like blue water. That's just the fishing activity. So the slide on the right takes out those fishing activities, and you can still see that there's quite a bit, but it doesn't just black it out on there. And I will point out on this slide while we're here, the pink slides that actually made some port calls out of Nome, that boat is listed as a passenger or pleasure craft, but it's actually a research vessel. And they get their permits through the State Department to do that. And this is, again, Russian flagged vessels that came to Alaska ports. You can see the research vessel again in purple. I bring that out. If you looked on what's called AIS, an automated information system, it tells you what kind of vessel it is, and you would go, oh, that's just a passenger vessel, but they actually are conducting a different kind of business. And this kind of breaks it down so you can see what's going on. There's not a ton of port calls here since 2010 that have came to Alaska. And, you know, as was mentioned, I think, by Representative Field, some of it's fishing. And this last slide I just brought up, I thought might be interesting. These are the Russian super yachts that some of the oligarchs have had that have visited right here in southeast Alaska. And last one was 2018. And I think one of these vessels actually been seized by another country at this time. But again, here's what's interesting. They're not flagged by Russia. They're flagged in Bermuda and the Cayman Islands. So there's often deeper analysis that you need to go to kind of figure out where this stuff comes from. And not just kind of talking about cargo coming to Alaska. There's not a lot of cargo ships that come from overseas directly to Alaska. A lot of our cargo will come from our bigger ports on the West Coast and then up here. And some of that's not even by cargo ships, but a lot, especially here in Southeast Alaska, by barge. So really the control points are probably down in the lower 48. And just to kind of summarize things, over the past 11 years, less than 20 commercial visits from Russian ships, and that includes those Russian-owned ones that are Liberian flagged, and less than 40 personal or pleasure port calls here in Alaska. And with that, I'm available for any questions or clarification.
All right. Are there any questions for Mr. White? That was fascinating. Representative Coppin?
And I don't know who's best able to answer this, but if we were to close our ports to, say, vessels owned by Russians, and there was an emergency situation, is there some workaround for that? Thank you.
Through the chair, Representative Coffin, an emergency situation, meaning we needed something from Russia and we weren't able to get it because we closed the ports?
I was thinking the other way. So a vessel's in distress, and we've said, no, you can't come to our ports. Is there a safety valve for that type of situation?
Through the chair, yes, there is force majeure. If anybody has a problem, they can claim force majeure, which gives them the right to pull into port. This is a common practice internationally, and it does allow for that to happen for safety reasons. It could be a mechanical breakdown, it could be a humanitarian crisis, but some reason that they need to come to port.
Do you follow up?
And so the bill as currently written would allow that?
Through the chair, I don't know all the details of the bill, but I don't think you can, Alaska could write a bill that would prevent force majeure. So, what's there?
And force majeure is that in international as well as U.S. law? Can you describe that for us?
Correct. Force majeure is an international law. It protects our vessels similar to other vessels that operate here. Maybe a U.S. boat that needs to pull into a foreign country for an emergency reason, and it's really for safety of life and protection of the environment, and it's extreme circumstances.
Okay, thank you. Representative Coppin, do you have any follow-up to that?
No, thank you.
All right. All right, thanks so much for your testimony. We appreciate that. I think we also have Captain Clayton Christie online. Captain Christie?
Yeah, good morning, Madam Chair and committee members. For the record, this is Captain Clayton W. Christie. I'm currently serving as president of Alaska Marine Pilots. We're a small group comprised of 10 captains mandated by the state of Alaska to provide pilotage services to vessels plying the coastal waters of Region 3, Western Alaska, to assure the protection of shipping, the safety of human life and property, and the protection of the marine environment. Region 3 encompasses all state waters west of 156 degrees west longitude, which includes the Alaska Peninsula, the Aleutian Islands, the west coast of Alaska, including the islands of the Bering Sea, and up along the northern coast to the Canadian border. We provide firsthand provide the pilotage services to these vessels, foreign flag vessels that are calling in Alaskan waters. And over the years, I'll mirror what Captain White said earlier in his presentation. We've seen Russian-flagged oil tankers. We've seen Russian-flagged research ships calling into the Port of Nome and Port of Dutch Harbor. And we've also seen Russian-flagged icebreakers during the calling in the Dutch Harbor and various other ports during the Shell years when they were doing their exploration up in the Chukchi Sea. And I'm available for any questions.
All right, are there any questions for Mr. Christie? All right, Representative Nelson.
Thank you, Madam Chair. Through the chair to Mr. Christie, you mentioned Russian-flagged icebreakers. And I know the U.S., we have a couple coming online in the near future thanks to our federal delegation. But would this, if this bill were to be enacted, would that cause any concerns or dangers to possibly utilizing some of those Russian-flagged icebreakers that are vital up on the north side of Alaska?
Through the chair, Representative Nelson, I would say no. To my knowledge, no, this will not harm.
Do you follow?
No.
All right, thank you. Mr. Anderson, thank you.
Through the chair, Representative Nelson, I can share one quick anecdote I've heard sort of along those lines. And apparently about 4 or 5 years ago, I wasn't able to find a photo, but apparently there was I think the city of Nome had run out of fuel in the springtime. And so there was a Russian icebreaker that did a fuel delivery to Nome. I think it was around 2018. I think that was the first time that's happened in quite a while, and it hasn't happened since. I think that story was brought to light to me after this piece of legislation was drafted, and it doesn't currently contain any kind of provision for emergencies, but I think that would be a welcome change. But it seems like those are very few and far between.
Do you follow up?
Yeah, follow up. Thank you. And I remember hearing that. I didn't want to quote it and be wrong, but no, that was exactly what I was thinking about, and we might have to look at something like that just until the U.S. icebreakers get online.
Yep, absolutely. All right. Thank you very much. Is there any additional discussion? Representative Schrage, want to make sure you had the opportunity to ask any questions. I've been trying to give long pauses, but in the event you have any questions, let me know.
Thanks for that. No questions.
All right, fantastic. All right, thanks so much to Co-Chair Fields and his staff, Evan Anderson, today, as well as all of the appointees who called in. Amendment deadline for the 3 bills we consider today, HB 405, 406, and 407, is Thursday, April 21st at 9 a.m. And we're planning on considering those on Friday morning. That wraps up our business this morning. Thanks so much for joining us today. Our next meeting is scheduled for Monday, April 18th at 3:15 here in Barnes Room 124. Thanks so much again to our secretary today, Leah Fraser, and our LIO moderator, Lydia Klein. This meeting of the House Labor and Commerce Committee is adjourned at 10:25 a.m.